Hello, law students. This is Mrs. Politsky, and I have notes for Chapter 5, Section 2, Intentional Torts, Negligence, and Strict Liability. So follow along, get your notes. Here we go. So there are some different common intentional torts. An intentional tort, this is a tort in which the defendant intended either to injure or to do a certain act. One might be, an example would be assault. This is when a person intentionally threatens to physically or offensively injure another person. It doesn't necessarily mean that you touch them, but it's the idea that you have maybe spoken some words that might lead people to assume that maybe that's what your intentions are. Anyway, the threat must be believable. So if there is like a physical threat, meaning that someone raised a fist to you, that would be included. Or it could be offensive, meaning someone saying something that is like an unwanted physical attack or unwanted sexual innuendo kind of attack or conduct on a person. Aside from assault, there's also battery, which in many cases usually kind of goes with assault. This is actually the harmful and offensive touching. This is like including things like shooting someone, um, pushing someone in anger, spitting on them, throwing something in their face. All of that would be considered battery because you're kind of like touching them and laying on hands. Normally, in most situations, an assault will precede a battery. All right. Battery without assault, this would be like being hit without any warning from behind. Sometimes that can happen. But no battery, there is no battery if the contact is not intentional. In other words, self-defense is not an example of battery. If somebody takes a swing at you and you put your fist up and maybe punch back, that and you injure someone, that would not necessarily be an example of battery. But you got to prove who threw the first punch. Aside from assault and battery, false imprisonment, this would be depriving a person of their freedom of movement without the consent of the individual or without some kind of privilege. A suspect at times may agree to be detained, but if they're being detained for maybe reasons that they do not know of, that could possibly come back as false imprisonment. Probable cause, like if I suspect someone, I'm going to detain them because I suspect that they're going to go out and do some harm to someone else, and I keep them from going out and doing that, that would not be a case of false imprisonment. Aside from assault, battery, and false imprisonment, defamation, this would be like kind of bringing false statements out into the public to damage someone's reputation. If you write them down and you speak them, they're different things. So a spoken defamation is known as slander, and a written one is known as libel. In this day and age, because of social media, both are really getting easier to prove because people record themselves or might have a phone and record someone else saying something. So, needless to say, there's probably a much better way of obtaining a paper trail for defamation than there ever has been. To legally be defamation, the statement has to be false, meaning that the truth is a complete defense. It also has to be communicated to a third person. So if I send a message out and someone takes a screenshot of that and posts it on Instagram, that might be your third party. And hence, if it gets posted out there for others to read, that could be the defamation right there, be it true or not true. Bringing in the victim into some level of disrespect or ridicule or humiliation, that also has to be proven. And again, social media has made it really easy to prove those kind of things, and people now are being held accountable for posting things online that they thought were, their right to post when it wasn't. So you have to be very cautious. The exception to this might be our politicians. Anyone who is a public official, you're going to probably get your name dragged around a little bit. That's part of politics. But even prominent personalities, prominent celebrities, they're kind of open because of the type of occupation that they have. Along with that, there's a issue of malice. The statements that were being spoken or written were known to be false when they were made, but they were intended to encourage people to freely discuss certain issues. So if a politician accuses his fellow lawmakers of being racist, he may not necessarily have meant that in such a way that he was saying this one person was, but he might have been saying that in such a way to get a dialogue going. Okay, it's kind of dicey, but it does happen. All right, other forms that we need to talk about. Invasion of privacy. This would be the unwelcome and unlawful intrusion into one's private life as to cause outrage, mental suffering, or humiliation. Personal and fundamental right, when we talk about invasion of privacy, is protected primarily when we start talking about like the Ninth Amendment to the Constitution, even though it's not really specifically worded saying right to privacy, but that amendment has been come to be known as a protection for that. Another thing as far as invasion of privacy, freedom from unnecessary publicity regarding personal matters. So if you don't want people to know, I mean, you should have a certain right to keep those things private. So needless to say that there's that. Aside from invasion of privacy, trespassing of land, this would be entering onto property of another without the owner's consent. This may consist of other forms of interference with possession of like property, like I have taken something, but it could be like property that could be intellectual property. So it might be certain ideas and such. Needless to say, intent is required to commit this tort of trespass. Conversion. This is using property in a manner inconsistent with the owner's rights. For example, I might have a building. It's not set up to be a skateboard park, as your picture shows here, and maybe I might have an individual who is using steps to my building for the purpose of a really cool jump for skateboarding. A thief, in many cases, is always a converter because they're using your property in a way that's inconsistent with your rights. But it could also be a situation where if I buy goods from maybe a person, that I might be the innocent buyer of a stolen good, and hence now I am a converter of that property. So we have to be very careful. When you talk about stores like pawn shops, they need to go kind of beyond their regular duties to make sure that their property that they're taking in has not been stolen, so that their customers don't become converters themselves. And number 8, interference with contractual relations, meaning a third party entices or encourages a breach, that the third party may be liable in the tort to a non-breaching party. So if two people are getting together and they are in the process of making a contract, that third party really has no right to interfere with that. And that's what that's basically saying. Number 9, fraud. This occurs when there is an intentional misrepresentation of an existing important fact. In other words, somebody is lying, maybe with the purpose of trying to make a sale, or perhaps maybe to entice individuals to contract. All of that would be under the guise of fraud or fraudulent activities. All right, moving on. What's negligence? Negligence is the most common tort. Intent is not required, but just carelessness. And duty and negligence, these are the general duty to imposed by the negligence law is reasonable personal standard. In other words, if I am a lifeguard, it's probably going to be assumed that I am going to be responsible for the safety and well-being of those people that are at that swimming pool. I would want to make sure that that employee was trained in first aid, that they were certified, and that they had up-to-date certification. All of that is to prevent this issue of negligence. So this requires that we act with care, prudence, good judgment of a reasonable person so as not to cause the injury to other people. And there are different degrees of care, like how you care for older kids versus little kids, how professionals care for patients or clients. All of that is, going to be defined perhaps by the job itself. Breach of duty and negligence. This is, again, the reasonable personal standard. It defines the duty. All right. Causation and injury in negligence, as with other torts, the violation of the duty must be the approximate cause of the injury. In other words, if I'm not paying attention and somebody gets hurt, then that's what caused the injury. Okay, something of that nature. And letter D, defenses to negligence. When you talk about common law, we can look at what previous things have been done. A plaintiff cannot recover for the loss caused by another's negligence if the plaintiff was contributing to the negligence. In other words, if they were messing around and somebody else was too, and somebody gets hurt, but both parties were, kind of at fault, there's no negligence here. So most states have substituted comparative negligence for contributory negligence. In other words, comparative negligence applies when a plaintiff is negligent. Their negligence action is partially at fault. Then the plaintiff is awarded damages, but they're reduced to the proportion of the plaintiff's negligence. In other words, they're not going to get millions of dollars. They may get money for paying for the care or treatment for whatever injury they had sustained because of that negligence. The assumption of the risk is another defense to negligence. There are certain jobs that are obviously far more dangerous, and if the plaintiff are awarded an award because of the danger, they must decide if they have subjected themselves to the risk as part of that defense. All right, what is strict liability? This is holding the defendant liable without showing negligence has resulted in the injury. Both the proof of the activity and the injury substitutes for the violation of the duty. So engaging in the following activities may result in the injury of a person that would make you liable, like target practicing, crop dusting with dangerous chemicals, blasting or storing flammable liquids in large quantities, perhaps maybe the ownership of dangerous or exotic animals like bears, tigers, poisonous snakes, elephants, monkeys, or the sale of goods that are unreasonably dangerous or defective, meaning that maybe a good that I'm selling in my store has a high level of lead, and if I'm selling primarily to children, that could contribute to some physical injuries that could arise. All right, thank you very much.